Good morning. I started this once already and I didn't have a glass of water with me, so that was not good. There's a lot of talking. This is going to be a long video. And for that, I apologize. But there are people in my comment section who don't read well and they don't understand things. And so I'm going to do my best to give everybody the fullest possible picture with sources and citations so that they can understand exactly what's going on, because there are a lot of allegations being made. People are telling me things like there are witnesses who came forward who said that the officers waited 4 minutes before they before they called the ambulance, and that the witnesses said it was attempted murder, but there's no record of this anywhere. There are also allegations that there are depositions out there, like complete depositions, and I haven't seen a full one yet, despite having asked for them repeatedly. And my opinion of that is that while they want you to see just the small portions, I don't remember seeing this or that or the other thing, what the deposition will show, my gut instinct, is that the deposition will show the FBI agents saw the gun and the gun was in Weinhaus's hand. That's what my instinct is. So it's interesting that they use depositions. I'm surprised at that. I can't think of why they would have done that. The defense did it. Maybe it was because the state wasn't going to call the FBI agents, and the defense wanted to determine why the state wasn't going to call the FBI agents, to see what the FBI agents had to say that might contradict before they put the FBI agents on the stand. Maybe. I don't know. It's not a very common thing. And depositions typically aren't, you can't use them, generally speaking, at the trial. You actually have to have the deponent there at trial so that he can be cross-examined and all that other fun stuff. Anyway, so let's look at this stuff. The first thing that we want to note is that he did appeal his trial. It was the appeal was rejected. The court found that there was no error of law, and he did motion for a transfer to the Missouri Supreme Court, which was denied. So his general appeals on the trial are done. So then he petitioned for post-conviction relief. He filed a petition alleging he had received ineffective assistance of counsel. And this is what I'm going to read to you. At least this is one of the things I'm going to read to you almost in its entirety. The Court of Appeals, and this is a Court of Appeals for the Division 4, the Eastern District Division 4 of Missouri. So it's not his county. These are people who've probably never heard of him up to this point. They are the ones who decided this. So this is, I know there are a lot of allegations that there is some giant conspiracy theory against Jeff Weinhaus, but there's literally nothing backing it up. So these are going to be the facts as were determined at the trial stage. On August 18th of 2012, Missouri State Highway Patrol Sergeant Folsom, received a phone call from Missouri Circuit Court Judge Kelly Parker regarding a video Movement had posted online, in which Movement in this case is going to be Jeffrey Weinhaus, in which Movement had threatened judicial officers, including Judge Parker. Sergeant Folsom reviewed the video. In it, Movement stated that the people will fire various Missouri officials, including the state courts administrator, as well as various circuit judges, lawyers, and policemen. Movement also generally referenced corrupt officials and his right to blast you motherfuckers out of there if we have to. Movement also stated, "We have the right to remove you use of force." Probably remove you through use of force. I don't know. Movement stated that September 14th will be the last day of the de facto court. You all are fired and will be considered trespassers after that time. And I'm going to pause for a sip of water or vodka. You decide. Delicious. Sergeant Folsom also met with Crawford County officials. Sergeant Folsom discovered that the 911 dispatch center and the courthouse had increased their security because movement had come to both places and had put everyone on edge. Sergeant Folsom consulted with other law enforcement officials, and they decided Sergeant Folsom should visit movement in order to determine whether he actually intended to harm anyone. On August 22, 2012, Sergeant Folsom and Corporal Mertens, went to Movement's home in Franklin County, Missouri. When Movement stepped outside his residence to speak with the state troopers, they detected a strong odor of marijuana. After discussing the videos with Movement, the state troopers asked Movement whether there was marijuana in the house. Movement replied that there was not. Sergeant Folsom and Corporal Mertens detained Movement until other state troopers arrived, and Sergeant Folsom obtained a search warrant to search the house. During the search of Movement's basement, state troopers seized drug paraphernalia, scales, a plastic container holding marijuana, a bag containing marijuana, and a small tin containing pills, which were later identified as morphine. They also seized computer equipment and video cameras. They found a gun in the nightstand of a dresser in the master bedroom of the home, but it was properly registered to Movement's wife and was not evidence of any crime, so they did not seize it. After the search, Sergeant Folsom gave Movement an inventory of the items they had seized, as well as Sergeant Folsom's business card. Shortly thereafter, Movement began sending emails to Sergeant Folsom asking for the name of Sergeant Folsom's attorney. Movement also fired a writ of replevin requesting his computers back. Movement called Sergeant Folsom's supervisors complaining that Sergeant Folsom had stolen Movement's computer, and Movement also posted a video online in which he said he should have placed a bullet in Sergeant Folsom's head. Movement also posted a video stating he was at his home with his guns loaded. This right here, this is strong indications. These are strong indications, or this combination of a sentence and a half, I guess. They are strong indications that Jeffrey Weinhaus was a sovereign citizen. Filing a writ of replevin to try to get his seized computers back is just ridiculousness. It is just paper terrorism. There's no excuse for it. Anyway, there are more factors which led me to my conclusion that Weinhaus was a sovereign citizen. But to continue. In the meantime, Sergeant Folsom had met with his supervisors, and they decided they were going to arrest Movement for possession of drugs and judicial tampering. Sergeant Folsom contacted Movement and arranged to meet in a public place. Sergeant Folsom did not want to go to Movement's home due to what Movement had said in the videos, and Sergeant Folsom was pleased to hear Movement make the initial suggestion to meet in a public place. Sergeant Folsom told Movement this meeting was for the purpose of returning Movement's computer equipment, but Sergeant Folsom planned to arrest Movement when they met. Sergeant Folsom also sought to have other law enforcement officials accompany him and Corporal Mertens when they met Movement. Sergeant Folsom contacted the Franklin County Sheriff's Department to assist in serving the arrest warrant, but no one was available. Sergeant Folsom then contacted 2 FBI agents they had worked with who agreed to go. The state troopers and federal agents were all at the gas station where they had agreed to meet Movement before Movement arrived. Sergeant Folsom and Corporal Mertens parked in a visible area near the road so they could see Movement arrive, and the FBI agents were in plain clothes and were on the other side of the gas station. Movement pulled into the gas station at a high rate of speed and was removing his seatbelt as he drove past the state troopers. Once Movement parked, Sergeant Folsom walked towards Movement's vehicle and began to talk to him. Sergeant Folsom was carrying a manila envelope containing the arrest warrant. Sergeant Folsom told Corporal Mertens to go to the back of the police vehicle and open the trunk so Movement would believe Corporal Mertens was retrieving Movement's computer equipment. Sergeant Folsom testified that Movement had exited his vehicle and was facing Sergeant Folsom in a bladed position at a 45-degree angle with one foot in front of the other. Sergeant Folsom stepped around Movement's vehicle and saw a holster on Movement's right hip that contained a handgun. While asking Movement why he had a gun, Sergeant Folsom removed his own handgun from the holster on his hip and held it down by his side in front of his hip. Movement said he was authorized to have a gun, and he moved his right hand to his holster and began manipulating the flap on the holster. Sergeant Folsom ordered Movement to get down on the ground, and Movement did not comply, but turned and squarely faced Sergeant Folsom. Movement opened the flap of the holster and placed his hand on the buttstock of the weapon. Sergeant Folsom raised his weapon and again ordered Movement to get on the ground. Corporal Mertens also ordered Movement to get down on the ground. Movement replied, "You're going to have to shoot me," and continued to draw his weapon. Sergeant Folsom saw the gun nearly out of the holster, and at that point he fired 2 shots into Movement's chest and 1 into Movement's head. Corporal Mertens also fired a shot at Movement because he believed Movement was a threat to Sergeant Folsom. Sergeant Folsom heard the shot and fired an additional shot into Movement's head. Movement collapsed onto the ground. Corporal Mertens called an ambulance, while Sergeant Folsom handcuffed Movement and took Movement's gun from his hand, with FBI agent Mike Marushak covering Sergeant Folsom. I'm going to pause for another drink of either water or vodka. You decide. Delicious. The state charged Movement with possession of a controlled substance, morphine, tampering with a judicial officer, possession of up to 35 grams of marijuana, assault on a law enforcement officer of the first degree against Sergeant Folsom, assault of a law enforcement officer against Corporal Mertens, 2 counts of armed criminal action, and resisting arrest. At trial, after the state presented testimony from Sergeant Folsom, the state offered a video into evidence. The video was taken from a camera that was on a watch that Movement had been wearing at the gas station, and it captured the entire incident. At the close of the state's evidence at trial, the trial court granted Movement's motion for judgment of acquittal on the charges of tampering and resisting arrest. The trial court concluded that Movement's threats against judicial officers in his video were not sufficient to support the charge of tampering, and that there was no evidence Movement was aware of. There is no evidence Movement was aware he was being arrested when he met the state troopers at the gas station. The jury convicted Movement of all counts but assault on a law enforcement officer against Corporal Mertens and the associated charge of armed criminal action. After a sentencing phase, the jury recommended sentences of 2 years for possession of morphine, 1 year for possession of marijuana, 30 years for first-degree assault of a law enforcement officer, and 30 years for armed criminal action. The trial court sentenced Movement in accordance with the jury's recommendation and ordered the sentences to run concurrently. This court affirmed Movement's convictions and sentence on appeal. He timely filed his motion, and he raised a few points. So let's go to the discussion. So he said that the trial counsel was ineffective for failing to call a crime scene forensic expert such as Gene Geitzen, who would have testified that Movement's movements on the video taken from the camera on the Movement's watch were inconsistent with Sergeant Folsom's testimony that Movement moved from a bladed position to facing Sergeant Folsom squarely. The appeals court disagrees. One of the things that Movement's motion had to allege was that this testimony would have provided Movement a viable defense. However, Movement's argument here is simply that this testimony regarding the body movements an expert could have inferred from the video taken from the watch on Movement's wrist that day would impeach the testimony of Sergeant Folsom that Movement began in a bladed position and then turned to face Sergeant Folsom directly. The failure to offer testimony that would have only impeach the testimony of the state's witness does not warrant relief for ineffective assistance of counsel. Rather, when the testimony of the witness would also negate an element of the crime for which a movement was convicted, the testimony provides the movement with a viable defense. Here, whether Movement moved from a bladed position to facing Sergeant Folsom squarely is not an element of any of the crimes for which he was convicted. The jury viewed the video, and Movement's counsel, while not arguing the video contradicted this particular testimony about Movement's body positioning, did argue the video was inconsistent with the state trooper's testimony in a number of ways. Even assuming arguendo, movement did not move from a bladed position to squarely facing Sergeant Folsom, the evidence that he was in the act of drawing a weapon when Sergeant Folsom shot him would be undisturbed. Thus, movement has failed to allege this testimony would have provided him with a viable defense, and so he was not entitled to an evidentiary hearing on the claim, and the point was denied. More water. This is tiring. So the second point was that counsel was ineffective for failing to call the FBI agents who were present at the gas station as witnesses in order to refute the testimony that Movement was wearing a holster containing a gun on his right hip. Again, the appeals court disagrees. Movement alleged in his motion that both agents testified in depositions they did not see a holster on Movement's right hip. Movement further alleged that had a holster been on Movement's right hip, the agents would have been able to see if Movement had been standing in a bladed position toward Corporal Mertens or squarely facing Corporal Mertens. However, there is no evidence at trial that Movement faced Corporal Mertens in either of these positions. Rather, the testimony was that Movement faced Sergeant Folsom and that Corporal Mertens was at a different angle. There is also testimony that the FBI agents were further away, across the parking lot. Therefore, Movement has not alleged unrefuted facts that the gun would have been visible to the agents had it been on Movement's right hip. Accordingly, even assuming the testimony that the agents did not see a gun on Movement's right hip was true, this does not provide Movement a viable defense. Moreover, while Movement alleges in a conclusory fashion that no reasonable trial strategy justified his trial counsel's failure to call the agents as witnesses, Movement has not alleged facts that would rebut the presumption that his counsel's decision was anything other than reasonable trial strategy. Movement's trial counsel argued in closing arguments an adverse inference based on the state's failure to call the agents to corroborate Sergeant Folsom's and Corporal Mertens' testimony, which he could not or would not have been able to do had he called them to testify. Further, Movement makes no allegation that the agent's testimony would have negated an element of the crimes for which he was convicted. Specifically, Movement does not allege they would testify that Movement was not disregarding Sergeant Folsom's directives to get on the ground, that Movement did not reach for a gun, and that Movement did not have a gun in his hand when they approached him after he fell to the ground. Denied. In his third point, trial counsel was ineffective for failing to call Levi Weinhaus, who is apparently a relative of Jeff Weinhaus, because Weinhaus would have testified that Movement wore his holster on his left hip while driving, contradicting the testimony that Movement was wearing a holster containing a gun on his right hip. Again, the appeals court disagrees. In his motion, Movement alleged that Weinhaus would have testified that Movement always wore his holster on his left hip while driving because the holster would interfere with his seatbelt. However, Movement does not allege Weinhaus was present or could have testified as to how Movement wore the holster at the gas station. Further, even if the jury would have inferred from Weinhaus's testimony that Movement wore a gun on his left hip while driving, this would not have contradicted the state trooper's testimony that the holster was on Movement's right hip by the time he was standing outside his vehicle. Finally, as addressed above, even if one assumes that the gun was on Movement's left hip rather than his right hip, this does not negate an element of any of the crimes of which he was convicted. Again, point denied. Finally, ineffective counsel for failing to call a video expert such as Jim Burney to testify that Movement's words on the video were actually, "You don't have to shoot me." Again, the appeals court disagrees. Movement alleged in his motion that Burney's testimony would have contradicted Sergeant Folsom's testimony when Movement said, "You're going to have to shoot me." However, here again, this is an allegation that only Burney's testimony would have impeached Sergeant Folsom's testimony. This alone, without an allegation, the testimony would have negated some of the elements of the crime is not sufficient to warrant relief. Additionally, the jury viewed the video. Movement's trial counsel, when cross-examining Sergeant Folsom, also raised the possibility that what Movement said in the video was, "You don't have to shoot me." Movement's counsel also argued during closing argument that Movement spoke softly in the video and could have been saying either phrase, noting the jury would have to decide what Movement actually said. Point denied. There was no dissent. The whole appeals panel agrees. Having failed the second round of appeals, Weinhaus then filed a motion in federal court. He filed a wrong motion under 28 U.S.C. 2554, I believe. The Declaratory Judgment Act, 2201, 28 U.S.C. 2201. And it had to be under 2254. There we go. So the judge at this point, actually I think it was a magistrate, a magistrate judge at this point, gave Weinhaus the opportunity to amend his motion, his request for relief, his petition for relief, to a habeas corpus against Steele, who was the warden. That's why you're seeing Steele's name. So in this one, the court, here we go. In this one, the Weinhaus tried to get a new hearing, or tried to get an evidentiary hearing that wasn't necessary. It was denied. And then this is the actual opinion of the magistrate judge. The first thing it does is lay out the facts. He was sentenced to concurrent imprisonment for 2, 1, 30, and 30 years respectively. They lay out the facts. We just read these facts. He pled various things. So his Sixth Amendment right of effective counsel, and then there's what's that? 8 points. Failed to place the FBI agents on defense's witness list. Failed to offer a screen capture or still photographs of the video made by his digital watch as evidence. Generally lacked the ability to cross-examine prosecution witnesses. Failed to call the county sheriff as a witness. Failed to object to the stun cuff device worn by petitioner at trial. Failed to request a mistrial after the judicial tampering charges were dismissed by the trial judge. Failed to call witnesses to show that petitioner was incapable of committing the crimes he was convicted of. Failed to demand the jury be advised of why the trial court dismissed the charge of tampering with the judicial officer, and failed to move to strike the YouTube video after the judicial tampering charge was dismissed. The next point he raised was his First Amendment right to freedom of speech was violated because they seized his computers. Then his Fourth Amendment was violated because they seized his computers. His Eighth Amendment rights were violated because of the stun device. It's cruel and unusual punishment. His Fifth and 14th rights to due process were violated when it wasn't when the court didn't declare a mistrial sua sponte. That means on its own, without a moving party. And when the court didn't provide a limiting instruction related to the YouTube video. And finally, that his 14th Amendment right to equal protection was violated for many of the reasons described in grounds 1 through 5. So the court will review these. Ground 1. So he's going to get ground 1 denied, but they're going to go into each one of them specifically. Decision to call a witness is a matter of trial strategy, and in rejecting this, the Missouri Court of Appeals stated, blah, blah, blah. Clear the Missouri courts for good reasons attributed to reasonable trial strategy. Counsel is not calling these witnesses as defense witnesses, and in doing so, the state courts did not reach a decision that was contrary to clearly established federal law, nor was their decision based on an unreasonable determination of facts. So that one was denied. The video still photos as defense evidence. The Missouri Court of Appeals reasoned that the petitioner's counsel was not ineffective for failing to call a forensic video expert as a witness. The state court decision in this regard clearly indicated that defense counsel's not calling a forensic expert to testify about what the video showed did not result in a jury verdict that was unreliable. The decision was not contrary to clearly established federal law, nor did it reach its decision based on an unreasonable determination of the facts. cross-examination of prosecution witnesses. He alleged for the first time that his defense counsel lacked any ability to cross-examine the prosecution witnesses and was therefore ineffective. Petitioner does not describe any specific error made by counsel during cross-examination or any instances where counsel should have cross-examined a witness but was unable to do so. The claim appears to be nothing more than a generalized grievance, as petitioner does not identify specific acts or omissions of counsel that, in light of the circumstances, fell outside the wide range of professional competent assistance. This ineffective assistance of counsel claim must fail. Without a factually specific allegation, there's no showing of a reasonable probability that the alleged error will affect the outcome of the trial. County Sheriff is defense witness. He argues for the first time that his defense counsel rendered ineffective assistance by not calling the local county sheriff as a trial witness to attack the validity of the search warrant which was executed at his home. A Missouri statute concerning the execution of warrants by members of the Missouri Highway Patrol provides as follows. The members of the Highway Patrol may request that the prosecuting or circuit attorney apply for, and members of the Highway Patrol may serve search warrants anywhere within the state of Missouri, provided the sheriff of the county in which the warrant is to be served or his designee shall be notified upon application by the applicant of the search warrant, except for offenses pertaining to driving while intoxicated. The sheriff or his or her designee shall participate in serving the search warrant except for offenses pertaining to driving while intoxicated and the investigation of motor vehicle traffic accidents. Petitioner contends that the warrant executed at his home by the Missouri Highway Patrol was invalid because notice had not been given to the local sheriff and the local sheriff's assistance had not been sought. However, Missouri courts have held that the use of the word shall in this statute is directory, not mandatory, and that parties challenging the validity of statutes in this manner must show that they have been prejudiced by such a failure. Under Missouri law, the failure to comply with the statute alone does not affect the admissibility of evidence. There has been no showing of prejudice to warrant relief under Missouri law. In any event, it's not Missouri law that's being enforced in this federal habeas corpus action. It's federal constitutional law. Counsel's performance cannot be constitutionally defective for failing to pursue a meritless claim under state law, and petitioner has not demonstrated that the addition of this witness would have changed the outcome of the trial. More water or vodka. Stun cuff restraining device worn by petitioner at trial. Petitioner next argues that for the first time that his defense counsel was constitutionally ineffective by failing to object to the stun cuff device placed on him during his trial. Petitioner claims that this caused a mental restraint and negative influence and was applied without the court's permission. Petitioner appears to rely at least in part on the Supreme Court's ruling in Deck v. Missouri, which held that the use of visible shackles during a trial was a violation of the criminal defendant's constitutional rights. Deck involved a defendant who was shackled with leg irons, handcuffs, and a belly chain. However, a criminal defendant's constitutional rights are only violated when visible restraints are used. The law has long forbidden routine use of visible shackles during the guilty phase of a jury trial. It permits the state to shackle a criminal defendant only in the presence of a special need. The law is the same in non-capital offense cases. In his case, petitioner did not allege that the stun cuff device worn by him during trial was visible to the jury and thereby prejudiced his case. Petitioner's failure to show actual prejudice by the wearing of the device establishes that this ground for federal habeas relief is meritless. Petitioner's allegations more specifically allege that the presence of the stun device in some way reduced his mental ability to participate in the trial. This allegation also fails as a matter of law because it is made in this court now for the first time. It was not raised in the state court. Also, he does not allege any specific way in which his mental participation in his trial was diminished in any substantial way by the mere presence of the device. He does not allege in any specific manner how, if his defense counsel had objected to the device, and if the objection had been sustained, his participation in trial would have been different and would have likely resulted in a different outcome. So it was denied. Failure to request mistrial after judicial tampering charge was dismissed. The Missouri court addressed it. It's not contrary to federal law, nor did it involve an unreasonable determination and application of the facts. The state court concluded that the video was not inadmissible character evidence as it went towards establishing petitioner's motive or intent, and the prejudicial effect was outweighed by the probative value of the video. The Court of Appeals found the inclusion of the YouTube evidence did not warrant a sua sponte order of mistrial, and petitioner has not shown a reasonable probability that, had counsel moved for mistrial, the outcome of the trial would have been any different. Failure to call witnesses. The petitioner was incapable of committing the crimes as charged. It fails on its face as a matter of law because it doesn't state any facts upon which he relies to establish his ground for relief. He doesn't indicate what manner he would be incapable of committing the subject crimes, what any witnesses would have testified to in support of such a position, whether he notified his defense attorney about any such witness in the expected testimony, or that any such testimony or related evidence would have made a difference in the outcome of a trial. So, denied. Failure to demand the jury be advised why judicial tampering charge was dismissed. Petitioner next argues that he should have argued that the jury should be notified why petitioner was acquitted on judicial tampering charge. Petitioner argues this resulted in the jury using now irrelevant video recording in arriving at the verdict. However, as discussed by the Missouri Court of Appeals and this court above, the YouTube video is the piece of evidence that sets this whole series of events in motion. It helped establish appellant's guilt of first-degree assault by showing his potential motive or intent to harm Sergeant Folsom, and its probative value outweighed any prejudicial effect it had on appellant. So, thus it is that the video is not rendered irrelevant and inadmissible on the charges that were submitted to the jury. Had counsel moved to strike it, the trial court would likely have correctly overruled the motion. Failure to move to strike video evidence is irrelevant. He next argues his defense counsel rendered ineffective assistance by failing to move to strike the YouTube video from evidence. As discussed above, it was properly admitted into evidence. Then the court addresses grounds 2 and 3 together. 2 was the violation of his First Amendment right, and 3 was the violation of petitioner's Fourth Amendment right. The legal context of his claim was stated by United States District Court for the Northern District of Iowa, albeit in a civil case, but also involving the issuance of a search warrant. Criticism of public officials lies at the very core of speech protected by the First Amendment. Retaliation by a government actor in response to an exercise of First Amendment rights forms a basis for a 1983 liability. To establish such a claim, a plaintiff must prove that 1, he or she engaged in protected activity, 2, the defendant responded with adverse action that would chill a person of ordinary firmness from continuing in the activity, and 3, that the adverse action was motivated at least in part by the exercise of the protected activity. A plaintiff claiming plaintiff claiming First Amendment retaliation in the form of retaliatory prosecution must allege and prove that there was an absence of probable cause to support the prosecution. Probable cause exists if, at the moment the prosecutor acted, the facts and circumstances within the prosecutor's knowledge and of which the prosecutor had reasonably trustworthy information were sufficient to warrant a prudent man in believing that the plaintiff had violated a criminal statute or ordinance. The requirement that a claim of First Amendment violation in the context of criminal investigation was reinforced in Bartlett, or Neves v. Bartlett, which we have discussed previously on this channel. While petitioner Weinhaus seeks relief from Missouri State incarceration by this ground as 2254 relief, that is the habeas corpus relief, and not as compensation or other relief under 42 U.S.C. 1983, the preliminary cardinal issue is the same: whether the Fourth Amendment's requirement of probable cause for the issuance of the search warrant for his residence was violated. So long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests in his discretion. Because petitioner's federal habeas ground 3 alleges the search conducted at his home violated his Fourth Amendment rights, the court considers petitioner's grounds 2 and 3 together. A Fourth Amendment claim of an unconstitutional search or seizure is not cognizable in a habeas corpus action unless the state has not provided an opportunity for full and fair litigation of the claim. Federal habeas courts are not empowered to examine whether a state court made an error of law in deciding the Fourth Amendment issue raised by petitioner. Search and seizure claims are only cognizable in habeas actions if the state courts provided no procedure by which a prisoner could raise his Fourth Amendment claim, or the prisoner was foreclosed from using that procedure because of an unconscionable breakdown in the system. This is true regardless of whether the petitioner actually sought relief in the state courts from alleged Fourth Amendment violation. if the state has provided no corrective procedures at all to redress the alleged Fourth Amendment violations, or if the state has provided a corrective mechanism but the defendant was precluded from using that mechanism because of an unconscionable breakdown in the underlying process. Whew. Boy, there's a lot of talking. And we're only on the 5th tab, boys and girls. Missouri rules of court provide criminal defendants have an opportunity to contest whether the prosecution acquired its evidence in violation of the Fourth Amendment. The record in petitioner's case in the circuit court indicates that no motion was filed to suppress any video evidence seized in the execution of the search warrant. The trial record indicates that the search warrant was applied for after the officers went to his residence to visit him after his threatening YouTube video was discovered. When the officers were at his residence, they knocked on the front door. Petitioner came to the door, and they immediately smelled the odor of marijuana emanating from the house and from him. After conversing with him about the video for 25 to 30 minutes, the officer asked petitioner whether there was any marijuana inside the house. Petitioner denied it. When the petitioner attempted to return inside the house, the officers restrained him, telling him they were going to apply for a search warrant, whereupon petitioner began screaming to someone in the house that the police intended to search the house for drugs. At trial, defense made no objection to the trial court's receipt into evidence of the search warrant in front of the jury. So the search warrant went into evidence in front of the jury. After the search warrant was issued, the officer returned with it to petitioner's residence, gave a copy of it to petitioner, told him he was free to leave. During the search of the residence, the officers found computer equipment, video cameras, a loaded 9mm handgun, and ammunition. The firearm was found in a drawer with paperwork that indicated it belonged to petitioner's paramour, who was also present. The photographs of the discovered items were received into evidence without objection. The discovered items, except the firearm, were seized by the officers. In a desk drawer on the main level, the officers found drug paraphernalia, several pills in a container, scales and marijuana in a container, and smoking pipes, all of which were seized. All the seized items were received into evidence at trial without objection. Also, in defense counsel's opening statement to the jury, he described the execution of the search warrant and the items that were seized. Petitioner has not shown he is prevented from raising any Fourth Amendment issue before or during trial. He had the opportunity to object at trial on direct appeal and in his motion for post-conviction relief to various pieces of evidence used against him at trial. No Fourth Amendment objection was raised at trial on direct appeal or in his motion for post-conviction relief. Without a state court determination of petitioner's Fourth Amendment rights concerning the search warrant issued for his residence, this habeas corpus court is without authority to assess whether petitioner's First Amendment rights were violated in the issuance and execution of the search warrant. That said, the record is clear that the state court search warrant for petitioner's residence was grounded on probable cause. That's what we like to call foreshadowing. Ground 4. Ground 4, petitioner alleges being required to wear a stun cuff device during his trial violated the Eighth Amendment prohibition on cruel and unusual punishment. The use of stun restraints at trial does not by itself violate the constitutional rights of the accused. Further, trial courts have a discretion to take security measures required to maintain order within the courtroom. However, Missouri courts have recognized that the prohibition on the use of restraints at trial is limited to restraints that are actually visible to the jury. As this claim was procedurally defaulted by petitioner, there being no state court opinion deciding it adversely to petitioner, this court applies the pre-AEDPA standard of review. In order to prevail under this pre-AEDPA standard, the petitioner must show a reasonable probability that the error complained of affected the outcome at trial, or that the verdict would have been different absent the now challenged defect. He's made no showing there. While he alleged that the use of the stun device constitutes torture in a number of other countries, this consideration is not relevant to the court's decision. Petitioner proffered no evidence that the jury in this case was aware of this device or that it was ever activated. In the absence of any such evidence, there is no reason to believe that wearing the device affected the outcome of petitioner's trial. Requiring petitioner to wear the stun cuff did not violate the Eighth Amendment's prohibition of cruel and unusual punishment. Ground 5 is the sua sponte stuff. It was denied. The Missouri Court of Appeals dealt with it. Failure to provide limiting instructions, similarly, it's denied. Failure to allow the jury to access frame captures. This ground for relief was addressed by the Missouri Court of Appeals and denied. Failure to allow petitioner's demonstrative evidence Petitioner does not specify the type of evidence that was to be offered, nor does he state that this unspecified evidence would have provided a valid defense or detracted from the state's case. The only clue offered by petitioner as to the nature of this evidence is that it would have presumably been offered to impeach the testimony of Sergeant Folsom and Corporal Mertens. He has not offered any specific basis for concluding that the state court's presumptive correct factual findings do not enjoy support in the record. So denied. Denial of due process from the use of the stun restraint. He alleges that his due process rights were denied when he was required to wear the stun cuff device at trial. The claim was not raised on direct appeal. He appears, not explicitly, to rely on DEC for the proposition that his due process rights were denied because he was required to wear the device at trial. Again, it's only violated when visible restraints are used, and the usage of stun belts and other restraining devices are justified by the same essential government interests that justify the use of shackles. As discussed above, he's presented no evidence that any jurors were aware he wore the stun cuff device at trial, so no due process right was violated. Ground 6 is 14th Amendment right to equal protection under the law. Many of the claims listed here are alleged elsewhere in the petition, are without merit, and are not discussed further. However, the petitioner also claims, as he did on direct appeal, that there was insufficient evidence presented at trial to convict him. That ground for relief is without merit. The Missouri Court of Appeals, in denying petitioner's direct appeal, summed up the relevant Missouri law and evidence that could have been relied on by the jury. It stated the relevant law as follows: a person commits the crime of assault on a law enforcement officer in the first degree if such person attempts to kill or knowingly causes or attempts to cause serious physical injury to a law enforcement officer. For a defendant to be guilty of an attempt to commit an offense, he must, with purpose of committing the offense, perform an act which is a substantial step towards the commission of the offense. Drawing the firearm is a substantial step towards commission of the offense. A substantial step is conduct which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. A mere threat alone is not enough to constitute an attempt to commit a crime. There must be strongly corroborating evidence that it was the defendant's conscious object to carry out the threat. Any person who commits a felony under the laws of the state by or through the use, assistance, or aid of dangerous instrument or deadly weapon is also guilty of the crime of armed criminal action. The appellate court described the evidence supporting the jury's findings thus: in looking at appellant's conduct before and during the act, it is clear that sufficient evidence existed for a reasonable juror to find appellant guilty beyond a reasonable doubt. Appellant's YouTube video repeatedly references the potential violent overthrow of specific government officials, and in one video, appellant says he should have placed a bullet in Sergeant Folsom's head. Further, appellant brought 3 loaded guns to a meeting with police officers. 3 loaded guns! And then proceeded to open his holster and rest his hand on his gun even after officers ordered him to the ground. Appellant also told Sergeant Folsom, "You're going to have to shoot me," in response to Sergeant Folsom pointing his weapon at appellant and ordering him to the ground. This stuff here that we're seeing right here, this is the memorandum for their information only, setting forth the facts and reasons for this order. That's what we're seeing there. The jury here, hold on a second. This court concludes that there was ample evidence for a rational jury to find that by bringing loaded guns to a meeting with police officers, opening his holster, resting his hand on the gun, and telling the officers that they were going to have to shoot him, petitioner took a substantial step towards assaulting Sergeant Folsom. The evidence further allowed the jury to conclude that petitioner was not issuing idle threats, but in fact intended to carry out an assault on the officer. Petitioner's statement he should have placed a bullet in Sergeant Folsom's head demonstrated an assaultive intent. A rational jury could find petitioner guilty of the assault beyond a reasonable doubt, and the state court was reasonable in upholding that conviction. Sorry, I need a drink of vodka or water, you decide. Because petitioner also employed a firearm during the attempted assault, the jury had enough evidence to find petitioner guilty on the armed criminal action count beyond a reasonable doubt, and the state court's decision in this regard was reasonable. Summing up the law and evidence relating to the possession of marijuana and morphine charges, the appellate court noted the following. Except under certain exceptions, it is unlawful for any person to possess or have under his control a controlled substance. Someone who knows of the presence and nature of a substance has actual or constructive possession of the substance. A person who, though not in actual possession, has the power and intention at a given time to exercise dominion or control over the substance, either directly or through another person or persons, is in constructive possession of it. Here, the bulk of the controlled substances were found in a desk in Appellant's basement, an area he referred to as his command center. Appellant's videos were all filmed with him sitting in the command center. On the day of the search, officer said Appellant smelled of marijuana, and further that once he was handcuffed, that he yelled into the house that the police were coming in to look for drugs. A reasonable juror could readily find from sufficient evidence on the record that Appellant had routine access to the area where the drugs were found, that his personal belongings were mixed in with the drugs, and therefore that Appellant exercised control over the area and likely the drugs themselves. The state was also required to prove, in areas where there was evidence of joint control over the premises, additional evidence connecting the petitioner to the controlled substance. The jury here could reasonably consider the officer's testimony that they detected marijuana on petitioner's person as well as in the house, that the controlled substances were found in a desk in an area of the basement that was accessed and used by the him. I don't know why they wrote by the him. That there was enough evidence here for a jury to find that the petitioner likely not only had access to the area where the substances were kept, but that petitioner had control over the substances themselves. There was enough evidence here for a rational jury to find petitioner guilty of the possession counts beyond a reasonable doubt, and that state court was reasonable in upholding these convictions. It is clear from this court's review of the record that there was substantial evidence to convict petitioner as it did, because the state courts did not reach decisions contrary to clearly established federal law, nor did they reach decisions based on an unreasonable determination of the facts. Ground 6 is without merit, and therefore no habeas corpus. Well, that was long, but we have more to do. First, we're going to go to this. This is contributed by Voice of Truth. He is very interested in Jeff Weinhaus. And it is contributed to the St. Louis Post-Dispatch. Now, there are other St. Louis Post-Dispatch. These are not contributed. This is by Jeremy Kohler. This is also by Jeremy Kohler. He is was a staff writer, investigative reporter. This guy is somebody who really, really likes Weinhaus. So we're going to look at this, and we're going to see the difference between the so-called true story and the real story. So he makes a trip to a remote gas station in an arranged meeting with law enforcement officers to have his printing press and equipment returned to him. It was computer equipment, not a printing press. I don't know if you've ever seen a printing press, but they're enormous. They're big, they're iron, they weigh a lot. 13 seconds after Weinhaus steps out of the car, he's shot 4 times in the head and chest. He had a weapon holstered on his left side, but he never drew it. Well, that is contradicted by the evidence. Weinhaus is now wrongly serving a 30-year prison sentence for assault on a law enforcement officer. The officer who shot him, Sergeant Henry James Folsom of the Missouri State Highway Patrol, testified in trial that Weinhaus pulled his gun, therefore he had to shoot him. Okay. There's overwhelming evidence at the time of trial to prove beyond a shadow of a doubt that Weinhaus was innocent, and yet none of it surfaced. His attorney, as well as a prosecutor, did not enter that evidence into trial. What evidence? The entire thing was even captured on a secret spy watch video, which, as we just read, was introduced by the state into evidence. The prosecution entered the secret spy watch video into evidence. He was denied due process and adequate counsel. You misspelled counsel there, counselor. And was falsely convicted. His crime was exposing government corruption. No, his crime was not exposing government corruption. His crime was possession of marijuana, possession of opiates, assault on a law enforcement officer, and the corresponding gun charge. For a decade before he was shot, Weinhaus was an active member in his community with a strong voice in local political corruption and advocated standing up for constitutional rights. He produced a political newsletter and videos under the name of Bulletin Man, challenging corruption and trying to build a better community. Many local businesses showed their support for him by running ads in his newsletter and stocking copies to distribute to patrons. Summer of 2012, Mr. Weinhaus ran an ad in a local paper asking for information on corrupt officials and activities. He got about 200 responses. They were all stored on his computers along with other equipment he used to produce his literature, were essentially his printing press. During this time, he was running for county coroner in an attempt to open up 2 old cases he believed carried some dark implications. The coroner had the power to arrest and even replace the county sheriff if necessary when illegal activities are uncovered. Okay. Why would he have to run an ad in a local paper asking for information on corrupt officials and activities if his paper was so awesome? In August 16, 2012, he released a video urging corrupt local officials to change their ways or step down. That's one way of phrasing what he said. His outspoken views do not sit well with some. August 22, 2012, 2 Missouri State Highway Patrol officers, Sergeant Henry Folsom and Corporal Scott Mertens, were sent to find Weinhaus and feel out his intentions in the video as well as his level of threat to himself or others. That is a relatively true statement. They spoke with Weinhaus outside of his home about the video. He explained his political platform intentions and intentions in making it. He was pushing for reform to broken systems and corruption, not advocating violence. Sergeant Folsom asked if Weinhaus would surrender his printing press and equipment. I'm sure Sergeant Folsom said printing press. So they could look them over. With his equipment being his livelihood as a journalist, and because his platform was pushing for the enforcement of constitutional laws and rights, he knew it was against the law for them to take it without a subpoena. Just a quick caveat, if they ask him to give them the computer equipment, it would not be against the law for them to take it if he gives it to them. If he gives it to them, they can take it. It's not against the law. It would be against the law for them to seize it without a subpoena, without a warrant. It'd be against the law for them to seize it without a warrant. Wow. Yeah, okay. It is also a violation of his Fourth Amendment constitutional right. I don't understand what he's differentiating. Oh, I think maybe he's trying to make a First Amendment claim and a Fourth Amendment claim here. He knew that they were not complying with the law, so he refused. When Weinhaus refused to hand over his equipment, Sergeant Folsom claimed he smelled marijuana. His corporal partner Mertens testified that he did not smell anything. That is a lie that is not borne out by the evidence. This is an important detail to pay attention to. We just read that the officers, plural, smelled marijuana. There was a strong odor of marijuana emanating from the house and from Weinhaus. Both officers smelled it. This is an important detail to pay attention to. Weinhaus's defense lawyer at his trial did not challenge this claim. Challenge the claim that he smelled marijuana. Well, they found marijuana. If a drug dog expert had been called as a witness, they could have testified that not even a trained dog could have smelled marijuana from that distance, let alone a human. What distance? They were on his front porch. The smell of marijuana came out of his home. They were talking to him. They were within talking distance with Weinhaus. This is the dumbest statement I've ever read in my life, and I've read a lot of dumb statements. This would have proven that it was an invented claim to gain access to the equipment. Well, the search warrant was for the equipment based on their discussion, their 20 to 25 minute discussion with Weinhaus, and for the drugs. They had 2 things on the warrant. Folsom informed Weinhaus he was going to leave and get a drug search warrant. No, he was going to get a search warrant. 4 hours later, he returned with the warrant. During that time, Weinhaus was handcuffed and detained in the front yard. When Folsom returned, he served the warrant alone. I don't know why you would suggest that. Without the sheriff, that's what he's going for. To serve a search warrant, Folsom was required to notify the local sheriff and have them present. He testified he had not been able to contact the local sheriff. His story later changed, claiming he did not have cell phone service to contact them. There are procedures to be followed in that instance, but they were not. And again, this is not a reason to this doesn't overturn anything. The evidence can still be admitted. The law does not make an exception. It does. Weinhaus's lawyer did not challenge in court as to why Folsom went ahead and served the warrant illegally. It's because it was frivolous. It would have been frivolous to do that. It had a material effect. We've read this. There were deputies from the sheriff's department present at the trial that could have testified to the fact that they would have been more than willing to assist in the search warrant if they had been notified. Doesn't matter. We've already heard that does not matter. They were called to the stand by Weinhaus's lawyer, but it was objected by prosecuting attorney Robert Parks, and that objection was sustained by the judge because it doesn't go to the admissibility of any of the evidence. They were not allowed to speak on Mr. Weinhaus's behalf because, again, it's irrelevant. During the search, they found a minuscule amount of marijuana and a prescription pill in the basement. Well, they found less than 35 grams of marijuana, and they found pills. And it wasn't in the basement, it was in his desk, in his command center. No matter what your bias is, the marijuana and pill found were inconsequential and irrelevant. The marijuana and the pill found were violations of not just state law, but federal law. And I am not saying, for those of you who are going to get all excited about marijuana and should be illegal, that's a political argument that you can make. And I support your political argument that marijuana should be legalized. Drugs should be legalized. That is my political philosophy. But the state of the law as it exists right now, or at the time at least, I don't know what Missouri's current law is, but marijuana was illegal. Prescription opiates are illegal unless you have a prescription for them. He then reiterates if a drug dog expert had been called to testify, it would have been proven that Folsom had invented the claim to gain entry. This guy, whoever wrote this, does not understand how experts work. Without the basis for a legitimate search warrant, except we've already read that there was a basis for a legitimate basis for the search warrant, entering his home became an illegal act, compounded by the fact that it was served illegally without a representative from the local sheriff's department. Well, they were there. Can you guess what they took? That's right, his printing press and equipment, which was part of the search warrant. They did not have a subpoena, which is required by the law. They had a search warrant, which was enough. They only had a fraudulently obtained and an illegally served warrant. Well, again, that's conclusory. That is not borne out by the facts. September 11th, 2012, Sergeant Folsom calls Weinhaus to let him know that he has been ordered to give back the equipment. He assured Weinhaus that he's not going to arrest him. Cops can lie. Folsom arranged a meeting at a local gas station. When you get your property back after a seizure, it is standard procedure to go to a police station and sign a receipt for your merchandise. This meeting was held at a gas station in a rural location in St. Clair, Missouri that was open for business and populated with citizens. Okay. Several officers testified in trial, including the shooting officer, that this was a ruse to arrest Weinhaus for a warrant they had obtained for the marijuana and the pills. They had also obtained a warrant for tampering with judicial official stemming from the video, which had already been cleared as free speech at this point by federal review. That's just a bald-faced lie. They had submitted this to a grand jury, I believe, by this point. Or maybe they submitted it to a grand jury after the shooting. I don't remember exactly right now. But the judicial tampering was not cleared as free speech by federal review. And I would love to have a citation for whatever that one is. The reason for the initial visit to Weinhaus's home was to gauge if he was a threat. If they still had any reservations about him becoming dangerous, planning an elaborate ruse to arresting him in a public, uncontrolled gas station with citizens and workers, points to negligence and deviation from procedure that did, in fact, put the public at great risk. It also left one man in critical condition with 4 bullet holes. That's a lot of hyperbole and stuff, but only one person was shot. We don't know if there were any other people there, and it was Weinhaus's suggestion to meet there. Jeff did not trust the situation and tried to get a pastor to go with him as a witness. He was unable to and went alone. He was wearing a spy watch, which was recording everything and sending it to his children's mother. On September 11, 2012, Weinhaus gets out of his car and has a gun holstered, as he always does, strapped backwards on his left hip. I guess this voice of truth guy was there to see it. His seatbelt made that the only position he could wear his holster in. Corporal Mertens has the trunk popped to support the ruse they were returning the equipment. Folsom asks him why he has a gun. Weinhaus remarks he is allowed to carry one, Second Amendment. Sergeant Folsom and Corporal Mertens would both later testify that at this point Weinhaus unstrapped his holster and began to draw his gun. They claimed that he was then instructed by Sergeant Folsom to remove his hand from his gun. That was before they knew about the existence of the Spy Watch video, where you can clearly hear the conversation. The Spy Watch video was introduced into evidence, and the jury heard it and listened to it. Any mention of Weinhaus touching or even motioning for a weapon is blatantly missing. The video, witness testimonies, and 2 FBI present at the scene can all confirm that Weinhaus never even touched his holster. That would be great. The video apparently did not confirm that. We don't know if the 2 FBI agents confirmed that, because apparently they said that they watched over, or that they had their guns out, their guns drawn, watching Weinhaus while Folsom secured the weapon that was drawn. It was on the ground. I don't know if I've already read that or if we'll get to it in one of the later things, but Sergeant Folsom changed his story to say he did not have time to tell him to remove his hand. Okay, I don't know where that came from. Sergeant Folsom then orders Weinhaus to the ground, followed by shooting Weinhaus once in the head, twice in the chest, and then again in the head. In trial, Folsom claimed that Weinhaus had pulled his gun and said, "You're going to have to shoot me, man." If you listen to the video, you can clearly hear Weinhaus say, "You don't got to shoot me, man." The jury listened to that video. Folsom claimed in court, Weinhaus said, "You're going to have to shoot me, man." A trained audio video expert can confirm that Weinhaus did in fact say, "You don't got to shoot me, man." Well, a jury apparently heard Weinhaus say, "You're going to have to shoot me, man." No expert was called in trial to challenge what was said. One even went to Winehaus's lawyer, Mr. Eastwood's office, the day before the trial. He insisted on being summoned to testify as an audio-video expert. He was refused. This potential witness had originally set the Spy Watch to go live when it was recording that day. His testimony could have proven invaluable to the defense. The best piece of evidence that existed to exonerate Mr. Weinhaus, explained by the expert who said it would have been the only tool needed to refute every claim made by the prosecution. Well, that's so much stupid. I don't even know where to start. I honestly don't even know what an audio-video expert is, other than someone who'd be able to, maybe run it, in this context, who'd be able to run the audio sample through some sort of a process to clean it up, to get rid of static, to, bring up the levels of the voice, things like that. But that's interesting. I don't know. Folsom also claims that the gun was holstered on Winehaus's right hip and that he unlatched the holster and drew his weapon. He claimed he had no choice but to fire his weapon. The audio-video expert would have been able to refute this with a still shot. I don't know about that. When he said, "You're going to have to shoot me, man," started to exit that gun from the holster and remove it in that posture, "I have no choice but to fire." When he said, "You're going to have to shoot me, man," and started to exit that gun from the holster and remove it. And in that posture, I had no choice but to fire. I don't know. Maybe he's quoting from something. I don't know. "I pushed him over to the left side where I could see the holster on his right side and the gun. I'm standing directly above him." Corporal Mertens also testified that Mr. Weinhaus was wearing his holster on his right hip. So where was the holster on Jeff? It wasn't on his hip. It was on the front side to the right. Both of these testimonies have been proven to be a lie. But did he have a gun? Yes. Did he draw the gun? Well, apparently. A still shot that had been isolated at the time of trial clearly shows a reflection of Mr. Weinhaus walking past the car with his holster on his left hip. Oh my God, it was on a different hip. This shot, as well as the FBI statements, are clear proof that Sergeant Folsom and Corporal Mertens lied about which side he wore the holster on. Doesn't matter. Again, doesn't matter. Right side, left side, they could have been mistaken. A parachute retention holster, which is the holster that Weinhaus used, is not designed to be a quick draw weapon. Apparently it wasn't, because they had a lot of opportunities to tell him to stop before he finished drawing it. It would have been it would have made it extremely difficult, if not impossible, for Weinhaus to unholster his gun and draw it in the short amount of time he would have had to do so. Apparently, he didn't finish drawing it, so yeah. According to that fact that the holster was, adding that fact that the holster was backwards on his left hip and Mr. Weinhaus was right-handed. I've heard now people claiming that Mr. Weinhaus was left-handed. So the stories change, but yeah. The FBI agents present swore in their depositions that Weinhaus did not attempt to draw his gun and the holster was not on his right side as claimed by Sergeant Folsom as his reason for shooting Weinhaus. I don't know if they actually claimed that he did not attempt to draw a gun. I believe that what we have is they didn't see. Do you remember see? Do you remember seeing? Do you remember seeing? I saw Weinhaus position his hands to his front waistband. I don't have any more than that. So he saw a weapon. Yes, I believe it was a block automatic. It looked like that to me, but split second seeing it. How much of the weapon did you see? Just the butt of the grip? No, almost the grip. So I don't know exactly what he's going for. Again, no one has gotten me the depositions, so it makes me wonder why I don't have the full depositions. Somebody has them and is just putting up things that they think are helpful, and they're not putting up the full depositions. I have a feeling the full depositions aren't as helpful as they want to believe. FBI agent stated in his deposition, so you'll have a little more of his right side. Yeah, his right hip. Did you see a holster? No. Did you see a gun? No. That's what he saw, but that's not saying that Marushak said that there was no gun there. FBI agent Cunningham, who was asked by Folsom to help serve the warrant, stated in his deposition he never saw a gun. I just remember him standing with his hands in front. There's a conversation going on between Sergeant Folsom and Jeffrey Weinhaus, and then seconds later I see Sergeant Folsom. He puts up his right hand and steps back, and there's shots fired. You say Sergeant seconds later was the seconds after. You say Sergeant seconds later was that the seconds after Jeff stopped. A time frame I couldn't. It happened real quick. I couldn't tell you how many seconds. When he stops, there's conversation taking place. Jeffrey Weinhaus has his hands in front. Again, the conversation takes place. Sure. That's when Sergeant Folsom raises his right hand, draws his weapon, steps back into the left, and then shots fired. And what happened to Jeff after the shots were fired? He fell to the ground. But was there a gun? He just said he didn't see him. FBI agent Marshak also verifies that Jeff did not pull the gun. Did you ever see a gun before shots rang out? No, I did not. That's not saying he didn't pull a gun. He's saying he didn't see it. Before shots rang out, did you see a holster? No. Did you ever see any movements by the hands up or down? No. Or I did not. I remember seeing the hands in front. He didn't see movements. We need the full deposition. The agent was asking the questions that were answered. The questions that were asked. None of these questions are, did Weinhaus have a gun? Yes or no? Did Weinhaus have the gun out? Yes or no? So I'm just saying that these aren't as conclusive as this author wants you to believe. Not only does Folsom claim Weinhaus drew his weapon and that it was on the right side, both of which have been proven a lie, but he also fully admits to executing purposeful kill shots instead of simply trying to incapacitate him if, in fact, he posed a threat. At that point when I fired my weapon, the totality of the circumstances hit me at the point when I actually saw that he showed up armed and was actually drawing a gun out of the holster. I don't know if those other people were involved, and to be honest, I was already looking past him and trying to scan to see if there were any more people back there that were threats. And when I first pulled my gun out, I fired two in the chest, and I saw both of them hit. He had a lime green shirt. I saw both those rounds hit, and on the way up, I fired one into his head and saw it hit his head. Let me just stop you there, sir. Where were you aiming? Just his chest and head. I purposely fired two in the chest and one in the head. Folsom also claimed that Weinhaus pulled a gun and he was forced to shoot. He also acknowledges there were citizens around in an uncontrolled atmosphere. In an uncontrolled atmosphere with two highway patrol troopers firing their weapon in public. Sergeant Mertens, Folsom's partner, fired off a couple shots as well. None hit Weinhaus, but two hit the building with two cashiers and customers inside. Well, 4 shots were fired by Folsom, and 1 shot was fired by Merton, and 4 shots hit and 1 shot missed. How did 2 hit the building? But anyway, this is all, I mean, none of this is relevant. The only relevant things, again, are the elements of the crime. Did Weinhaus start to draw the gun? Was he drawing his firearm? All this could have been avoided if protocol had been followed by having Weinhaus go to the police station. Okay. Again, I don't know what protocol you think there was. Maybe they thought that there would be an issue getting him to the police station. I don't know. Folsom and Merton's claim that Weinhaus pulled a gun is proven false by video evidence, FBI witness testimony that were not made available to the jury in trial. The video was made available. The FBI, the defense, could have called the FBI and witness testimony. Your expert witnesses, I don't think, are very valuable, to be perfectly honest with you. Their claim that Weinhaus's gun was holstered on his right side has also been proven wrong by the video, still shot, and FBI statements. Well, they didn't see it. It wasn't proven wrong by them. The video, again, the jury saw it, and the still shot, they saw the video. I mean, just one frame from the video doesn't necessarily mean anything. Folsom claimed that he holstered Jeff's gun when he pulled it out from under him. Folsom claimed that he holstered Jeff's gun when he pulled it out from under him. And I rolled him over. I see that gun there. I reached down, grabbing the gun and shoving it in that holster that was right there. If Folsom had admitted the gun was in the holster when he removed it from Weinhaus, it would have proved it was not possible for him to have drawn his gun. He would have had to return the gun to the holster as he was falling to the ground while being shot 4 times. If Folsom had admitted that the gun was in the holster when he had removed it from Weinhaus, it would have proved that it was not possible for him to have drawn his gun. I don't know. They claimed the gun was out of the holster when Weinhaus was shot was proven wrong by FBI Marashak, who said this when asked when the first time he saw the gun or holster. Sergeant Folsom was in the process of removing it from underneath Winehaus's body. When I made the approach, I had no idea a weapon was involved. At that point, gun. I've got to get it removed. He tries to get his hand out underneath Winehouse's body. At that point, I see the olive drab holster and a weapon in it. Once again, Folsom's version of the story has been proven untrue, but the jury did not hear that testimony of those FBI agents. Well, I don't know what to say about that. It'd be lovely to see the depositions. But again, the jury found that Weinhaus was in the process of drawing it. It might have still been in the holster halfway out. I think we saw it was halfway out, didn't we? In one of the things we read. If the gun was still in the holster when it was pulled from under Winehouse's body, he could not have drawn it. Well, he was drawing it, is what I believe the allegation was. It's as simple as that. He is in prison because 2 men, the man who shot him and his partner, maintained their lives through the entire trial. The testimony of the 2 Missouri State troopers, Folsom and Merton, is backed up only by their words alone, which contradicts every other single person's presence version of the events, as well as the video and audio evidence. Again, the jury saw the video. The jury saw the video. There was no investigation into the actions of Sergeant Folsom and Corporal Merton in the shootings by the Sheriff's Department, the FBI, or any other agency. It was all done in-house. They were investigated by their peers. And I might want to point out, Weinhaus was convicted. So it was a good shoot, because Weinhaus was convicted of assault with a firearm on a law enforcement officer. A chilling dispatch call recorded catching the head of the highway patrol and the dispatcher saying, "Yeah, there's supposed to be a Jeffrey Weinhaus guy. Are you familiar with that name? Oh no, they're messing with him. Again, maybe he's learned his lesson this time." Click to listen. So, who made the highway, catching the head of the highway patrol and the dispatcher saying, "Yeah, there's supposed to be a Jeffrey Weinhaus guy. Are you familiar with that name?" And then, "Oh no, they're messing with him again. Maybe he learned his lesson this time." I don't know what. There's too many pronouns. I have no idea who they're talking to or referencing. And there's things that are cut out. There were men working on the gas station's gutters at the time. One witness states, click to listen, very clearly and emphatically that Weinhaus did not have a gun in his hands when he was shot, and he believes it was a setup and murder. He states that there was no attempt to help Weinhaus on the scene, and within 30 seconds, the parking lot was swarming with officers. The shooter had his hands taped up and immediately left and did not return. The shooter had his hands taped up, probably to get the evidence, the residue and stuff. I don't know. Another witness verified that Jeff did not have a gun in his hands at any time. Both of these two witnesses and the two FBI agents verified Weinhaus had not pulled his gun. Again, the FBI agents did not verify Weinhaus had not pulled his gun. And what are the names of these witnesses? And where are their witness statements? I mean, I've already proven that this guy's lying. He lied about the pill, and he's lied about the video not being played at trial. So I have to take all of this stuff as he's a liar. FBI agents that were present during the shooting were in the courtroom, ready, willing, and able to testify, but they were not called. After hearing their depositions, Robert Parks, prosecuting attorney in the case, removed them from the witness list. Weinhaus's lawyer did not call them to the stand. We've already read about that. That was a trial strategy. One of the bullets entered Weinhaus's temple and came out his forehead. This is believed to be the last shot that struck him, leaving a bullet in the ground next to where his head fell. Click to see the photo of the bullet. No crime scene team was brought in to investigate the shooting. No expert was brought into trial to show the bullet fired into his head when he was on his way to the ground after already having been disabled by 3 previous kill shots, if they're not kill shots if he didn't die. It can still be easily proven after the fact by watching the video. They've watched the video. You can see the sergeant's hand position as he shoots. The angle of the gun to his body and the angle of the gun's path through Weinhaus's skull proves it was a kill shot while he was already twisting on the way down. Yeah, he was on the way down. He was on the way down, and there's no link to that. Sergeant Folsom stated in his deposition, I already fired 2 in his chest and 1 in his head. I immediately started scanning left. I knew that I had to eliminate him as a threat. I saw his eyes roll up in his head, and it was just the whites of his eyes that were showing. When the first 2 rounds hit, he was just kind of standing there almost like he was in amazement. I saw his eyes roll up in his head. I could still see Jeff's got his hand on the gun, and I heard that shot go off, and he started to rotate. I just chose my sight, went back to his head. I squeezed the trigger again. He's already starting to rotate and fall. He fell, and I mean he fell. I mean he fell violently. I mean he collapsed on his face and just piled up. He was on his way down. So Sergeant Folsom admitted he fired the last shot after he acknowledges that 3 previous kill shots had already taken Weinhaus down. Just because you can see the whites of his eyes doesn't mean that he's down. He heard another shot, and he thought he was being shot at. He was standing there in amazement. He started to rotate. I chose my sight, went back to his head, and squeezed the trigger. He's already starting to rotate and fall. He was not down. He made the choice at that point to aim again at Mr. Weinhaus's head, make a shot that rips through his temple and out his forehead as he's pivoting to the ground. This is full admittance of the last shot fired from Sergeant Folsom's gun was intended to kill. Yeah, but you can use deadly force. Bullets coming out are already like prima facie intent to kill. Assault with a deadly weapon. Maybe it's not necessarily prima facie evidence of intent to kill, but if you shoot at someone, you can be charged with attempted murder simply by shooting at someone. Even if you say I intended to shoot him in the leg, it doesn't matter. It's most likely going to be attempted murder because you shot at them. But yeah, Sergeant Folsom absolutely did shoot at him, and he hit him 4 times, twice in the chest, twice in the head, all of which could have killed Weinhaus because he wasn't trying to tickle him. Because the video made calling out corruption, certain people took offense. An illegal search and seizure led to a dangerous situation to everybody involved, innocent citizens included. It was all just to serve a warrant to someone who would have willingly walked into the police station and turned himself in if needed, citation needed. Jeff Weinhaus thought the police were corrupt. He thought the courts were corrupt. He thought judges, lawyers, everybody was corrupt. This then led to Weinhaus being flown to a hospital barely alive with 4 kill shots in his body. He was The ambulance was called, and he was treated by life flight. The evidence has proven that Weinhaus is innocent. No, it hasn't. His crime was exposing government corruption. No, it wasn't. His house was raided. Yes, it was. His computers were stolen. No, they weren't. They were seized. He was shot when he went to retrieve them. That is true. He was brought up on tampering charges for the video, along with the assault charges that landed him in prison, but they were dropped as unfounded. He was brought up on tampering charges, tampering with the judge, yes, and resisting arrest, but they were dropped as not necessarily being unfounded, but that they could not be proven. The judge said that there wasn't enough evidence to support them as a matter of law. The entire reason they started this process didn't even hold up in court. Right, but he drew a firearm after that. But the assault charge stuck because he drew his firearm and he never touched his gun. That is not true. He is in prison for another 30 years for armed criminal action and insulting Sergeant Folsom by shooting him. No, for assaulting him by drawing the firearm, or by starting to draw the firearm, attempting to draw the firearm. The only evidence against this man is the words of the man who shot him and his partner. Overwhelming evidence proves he is innocent. He had the gun on him. The gun was apparently out of the holster. I don't know why you're trying to say that overwhelming evidence proves he's innocent. Sergeant Folsom did not even try the fact he was shooting to kill, not incapacitate. Witnesses were terrified. They were screaming, blah, blah, blah. They saw a plainclothed man shoot another man in front of them. Bullets were hitting the building. Nobody that was there other than the shooter and his partner claimed that Weinhaus pulled his gun. This is terrible writing. Witnesses also report that there was no effort made to help Weinhaus at the crime scene to stop the bleeding. It took the ambulance 8 minutes to get there. He was eventually flown in critical condition to a hospital and is alive today only by the power of God. Show me the witnesses. And if a man's been shot twice in the chest and twice in the head, what exactly would the officers have done for him? What would they have done for him? He was shot twice in the head, twice in the chest. One of the bullets went in his temple and out his forehead, according to you. What would they have done for him? Put a Band-Aid on it? Don't be retarded. Mr. Weinhaus had a video camera in his car recording that day. It could have shed an entirely different light on what happened. This video has not been seen or heard of since. Its existence is not acknowledged by the Missouri State Highway Patrol or the Franklin County Sheriff's Department. Then how do you know it was there? Another incident that was not explored in trial was the fact that Sergeant Henry James, and this isn't even raised. Never mind. I'm going to get to other things. Another incident that was not explored in trial was the fact that Sergeant Henry James Folsom, the shooting officer, was involved in a previous altercation where he shot and killed someone on duty under questionable circumstances. Stating the circumstances are questionable doesn't mean anything. This article was written under questionable circumstances. The author could have been high on the marijuanas while he was writing this. He could have been, I don't know, finger banging an albino midget. Questionable circumstances, we just don't know. It resulted in a lawsuit against Folsom and the other officer involved. Lots of things involved in lawsuits. The judge did not allow the jury to have any information about the previous shooting and death because it is not material. Folsom was not on trial. The question are, did Weinhaus assault him by starting to draw the firearm, attempting to draw the firearm, however you want to phrase it? And the jury found, beyond a reasonable doubt, that he did. At trial, Weinhaus was forced to wear 80,000-volt shock cuffs, even though the court did not have authority to use them in the situation. A judge in Maryland was just convicted for doing this. For making him wear them? I don't know about that, but apparently the federal courts disagree. And apparently Missouri courts disagree because the federal court cited Missouri courts' decisions. From prison, a good friend was recording phone calls from Mr. Weinhaus to upload online so he could tell his story as well as deliver uplifting messages to those at home who missed him. Well, isn't that a feel good? On February 22nd, 2018, Weinhaus was served a cease and desist order forbidding him to have his voice recorded and put on the internet. If he chooses to exercise his freedom of speech, he will face solitary confinement, loss of any privileges, including email, phone calls, and visits. Why? Why was he, assuming arguendo that that is true, why? Is it because he was making defamatory statements? Is it because he was making false statements? Isn't that a good question? April 26, 2018, he mailed out a letter entitled "Reasons Why I'm Innocent" to his friend who posted the letter online. Ooh, well, that means if he sent out a letter saying why he was innocent, I mean, he must be innocent, right? The decision to silence Weinhaus, even now from prison, has been taken as far as to serve him on May 22, 2018, with the conduct violation of the silence order for the letter being put online. The violation report cited that he had created a disturbance. He was placed in solitary confinement and stripped of his privileges. He's been silenced for telling his side of the story. The violation report cited he created a disturbance. Well, I'd love to see that violation report. Mr. Weinhaus was shot in an attempt to silence his voice. It didn't work. He lived. They silenced him in court with shot cuffs. There's no evidence of that. They never used them. They silenced him in prison, but the facts do speak. You just have to listen. Blah, blah, blah. So, this is actually true. Okay. So now what do we know about the way the actual St. Louis Dispatch thinks of him? Gadfly figures he's worn out his welcome in St. Francis County. 3 years ago, Weinhaus retreated to the woods of St. Francis County to run a drive-through holiday lights extravaganza called JC's Christmas and Lights after his frenetic and free newspaper trashed so many people in Jefferson County. In Weinhaus's worldview, politicians are commies, cops are ESS, lawyers are godless pagans, and Jesus is coming. High on his list of conspiracy theories is America is enslaved by a satanic cabal of banks, oil companies, and Freemasons. Does this sound sovereign citizen-y enough? His newspapers, the Bulletin and its successor, the Provocateur, are mostly stream of consciousness diatribes he writes in a single session. His views have earned the 35-year-old publisher his share of enemies, but also 10,000 readers and a loyal cadre of advertisers. Over 3 years in his new county, the Festus native made enemies in places high and low. Now he's serving a month in jail for contempt of court. He's also reached an agreement with his landlord to leave by December 31st. They all want to see me get down the road, Weinhaus said in a jailhouse interview that week, so I'm going. Essentially, he ran against the sheriff. He lost by 10,000 votes. He trashed judges. He had raves during the summer at his JC's Christmas of Lights. The people got an injunction against him from holding those raves. He violated the injunction, and the judge tossed him in jail for contempt. So, and in the days after the September 11 terrorist attacks, a billboard went up at the Weinhaus's facility overlooking Highway 67. It said, "American Terrorist, 24th Judicial Circuit." Anyway, the only other recourse I have is to shoot people, but that's not the way. He said Jesus said choose life. Yeah, so I mean, there is a history with this guy, right? And then this is what the St. Louis Dispatch reported the day after the shooting. Police critic is shot in run-in with Missouri patrolman. For years, Jeffrey Weinhaus preached across 2 states that a cabal of communists, Freemasons, and devil worshippers had taken over the United States of America. On his YouTube channel last month, Weinhaus called for the forceful overthrow of local officials if they did not step down by September 17th, but Weinhaus was the lone casualty of his revolution after a series of events that ended Tuesday with his critical wounding by the police he despised. In a newsletter called the Bulletin, distributed in Jefferson County in the 1990s, then on a website, and finally in stream of consciousness video diatribes on YouTube, Weinhaus, known as Bulletin Man, railed against police, lawyers, and judges as evil agents of false government. Some dismissed Weinhaus 46 as a harmless showman or derided him as a lunatic, but he had advertisers and thousands of readers. More than 3,000 people viewed the video ultimatum to local authorities he posted August 16th. What I've been trying to lay down over the last 16 years is my right to go in there and blast you motherfuckers out of there if we have to. You're going down one way or the other. Soon after he posted the video, Missouri Highway Patrolman seized Weinhaus's computers from his home in Franklin County, sending him into a frenzy. Police would not say why they took the computers. In his most recent video posted Sunday, Weinhaus said his third wife had kicked him out and he was totally out of my mind, totally clinically insane. He reiterated his threat to authorities. I showed remarkable restraint the other evening, and I actually believe the Highway Patrol tried to set me up into firing at them. I mean, they left my gun chambered and safety off. On Tuesday, 2 officers with Missouri Highway Patrol's Drug and Crime Division arrived to meet Weinhaus at a gas station on Highway K near St. Clair. The station was near Weinhaus's residence, police say. Police had a warrant for his arrest from Franklin County for 2 counts of possession of a controlled substance and 1 count of tampering with a judicial officer. Bail was set at $50,000. A news release issued Wednesday morning by Patrol Sergeant Al Notham gave the following account of what happened at the parking lot. This is the official story. Never trust the official story. And then he spewed vitriol, and Jefferson County Sheriff Oliver Glenn Boyer said that he reads it. He moved to St. Francis County. He ran an anti-corruption on a corruption-busting platform, but lost the incumbent. The attacks on Bollock did not cease in the bulletin, and blah, 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 basically rehashing. So that is what the St. Louis Post-Dispatch says. This is not really, this is obviously a propaganda piece. But we have more, because there's always more. And we're going to go to this. All right. So this is the E-Missourian. Let's see what, I'll give you a date on this one. This is from December 8th of 2012. I want to point out in here that I don't remember what I wanted to point out in here. Notice that none of these are reference any witnesses, by the way. Any witnesses to the shooting, any bullets hitting the building, nothing. None of these mention it. Anyway, I think there was something in here where he was acting sovereign citizen-y. He's been a defendant in a number of civil and criminal legal cases arising out of Jefferson, Franklin, and a number of other Missouri counties. So he's got a long and sordid history. He is, upset that the system doesn't work the way he wants it to. And there you go. Let's see what this one is. Oh, so Trooper criticizes Missouri Highway Patrol during his testimony. Assuming arguendo that this was a hit, or that this was some sort of a conspiracy against Weinhaus, this right here, this article puts a real big nail in it. Well, there's lots of things that put nails in it. Like if the holster was on the left hip and not the right hip, why wouldn't Trooper Folsom have just, they know all this stuff. Why wouldn't he have just said the correct hip? If it wasn't an honest mistake, why wouldn't he have just said the correct hip? Why would he have to lie about what hip the holster was on? We know there was a holster there. We know there was a gun there. Why would he have to lie about the hip? But anyway, I'm almost out of water or vodka. You choose. And my voice is going, but whatever. Sergeant Folsom's comments during the sentencing phase of the trial took many observers in the courtroom by surprise. Franklin County Prosecuting Attorney Bob Parks called Folsom to the stand and asked how the shooting had impacted his life. This is during sentencing. The prosecution will often call people to, basically try to persuade the judge to give a harsher sentence. And in fact, Bob Parks was trying to get the sentences, the recommendations of the jury to run not concurrently, consecutively. So it would be like 63 years instead of 30. In some of the more dramatic testimony of the trial, Folsom told the jury that it changed his life forever and it devastated his family and his career. He said he now suffers post-traumatic stress disorder as a result of the shooting. After I arrested or tried to arrest Mr. Weinhaus, Jeff's friends on Cop Block posted stories about how I lied and put pictures of me shooting Mr. Weinhaus. My family and friends see that when they Google my name, Folsom testified. He then suggested that Missouri Highway Patrol didn't stand by him after the shooting. My employer didn't do its job. They turned their backs on me, Folsom said. Folsom said he only received 1 day off after the shooting, even though he requested more time off. He indicated he has been on medical leave for a period of time. When I complained, my boss rubbed me off and out. I didn't want to go and arrest him, Weinhaus, but because he called the wrong person a motherfucker, I lost my job. I'm 8 years from retirement now. In 5 or 6 months, I won't have a job, he said. Lieutenant John Hotz wouldn't comment on it. So I don't have it up here, but Folsom did lose his job. He got post-traumatic stress disorder from this. Now, he had post-traumatic stress disorder from the first shooting, but you get cleared. They do psychological evaluations on you. He was cleared to come back. And you will find in my limited time of being an attorney, I have worked with firefighters and police officers on various things, and they all the ones that I have worked with have post-traumatic stress disorder. Firefighters and policemen, apparently it's just a thing. You go into those life and death situations, fighting fires, getting shot at, having to shoot people, etc. You just end up with a certain level of post-traumatic stress disorder just from the stress. And post-traumatic stress disorder is a mental health condition that's triggered by a terrifying event, either experiencing it or witnessing it. Symptoms may include flashbacks, nightmares, and severe anxiety, as well as uncontrollable thoughts about the event. The trooper did not enjoy shooting Weinhaus. That is why he got post-traumatic stress disorder from it. If his intention was to go there and kill Weinhaus because he, for some reason, didn't like Weinhaus or whatever, obviously that didn't pan out well for him. It does not appear from this that was his intent. Weinhaus was given a 30-year sentence. If it is a big conspiracy theory, one would have to wonder why he only got 30 years. The prosecuting attorney recommended consecutive rather than concurrent sentences. That means he would have served like 63 years. The jury recommended a sentence that added up to 63 years on all the charges. And the judge affirmed the sentences, but ordered they be served concurrently. If the judge is against him, why would the judge have done that? Because apparently he could have given him consecutive rather than concurrent sentences. And again, the two charges that were dismissed by the court also would indicate that the court was not biased against Weinhaus. And why did I want this one? Oh, yeah. After being sentenced, he went off. Weinhaus asked Sutherland if he could be unshackled before addressing the court, and the judge allowed one of his arms to be unrestrained. He launched into a rambling 25-minute diatribe in which he cited the Missouri and the United States Constitution as well as the Bible. He attacked his attorneys, the Highway Patrol, Parks, and Judge Sutherland. You are a black-robed terrorist, enemy combatant. You are no different than Osama bin Laden. He also referred to the judge, law enforcement officer, and Parks as predators. Weinhaus called the proceedings a kangaroo court, and the patrolman who shot him as cold-blooded murderers. Who did I hurt? Who did I offend? The only victim in this courtroom is me. If I go to jail, that's what revolutions are made of, he said at one point, adding he is not responsible for any actions by the militia. Weinhaus said his arrest was ordered by Governor Jay Nixon, who he said he knew because they were from the same county. Guy's fucking off his rocker. Anyway, he had to be restrained while he's being led away on his way out. I'm not going to threaten you, but you come against a child of the Most High God. Woe unto you! You are doomed! And then I don't remember why I wanted to show you this one. You know, he's making an effort to have it overturned. I don't know why I wanted to show you this one. It's been a long time. I don't know if anybody's even still watching. But here's some fun things. Here's some fun things. You might have noticed that this Weinhaus v. Steele referenced Neves v. Bartlett, a 2019 decision. That is because this was, in fact, decided on August 13th of 2019. This one was in July 27th of 2018. You may remember that the initial shooting was on, there was a grand jury on Wednesday, November 27th, blah, blah, blah. That's why I wanted to show you this one. There was a grand jury indictment. These are from 2012. I think it was like September something of 2012 is when Weinhaus was shot. So any of these things, these witnesses, all these things that are being claimed, the governor, being against him and all this other stuff, you have to wonder why they didn't even appear in any of the arguments he made to the federal court in 2019. Why? Is it because they're being made up? Weinhaus has had a lot of litigation. The courts have thoroughly addressed all of the points that are being brought up that are somehow supposed to exonerate Weinhaus. I don't understand why people are. The only way that you could be of the opinion that Weinhaus is somehow supposed to be free is if you inherently distrust the police. The courts treated Weinhaus fairly. He was given his appeals. They treated his motions appropriately. They discussed the various issues that he raised, especially in the federal court decision. They discussed it at length. He's had every opportunity in the world. And new allegations seem to come out, and stories seem to twist, which indicate to me that we're being lied to, that you're being lied to. So I hope this was helpful. I will have all of these links in the channel description, or not in the channel description, in the video description. My voice is shot, so I'm done. Thanks for watching. Have a great day.